نحمده ونصلي على رسوله الكريم أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to another Business Matters program on Radio Al Ansar. Yes, if it's Monday evening, you with me, Anwar Moolla. And tonight we have an exciting program with two guests in the studio who I'll introduce to you to shortly. We're talking tonight about family businesses, planning around family businesses, and how one can leave a legacy going forward without causing problems. And we have two specialists in the studio tonight from a legal firm called Patta and Patta, and I've been reminded to introduce them as the law firm of the year 2024. Was that KZN, Zahra? So yeah, two specialists from Patta and Patta tonight with us. And I'm going to introduce them just now, but I'm going to kind of steal 2 minutes from the program to talk a little bit about Eid al-Adha, and I wish everybody had a wonderful Eid al-Adha, and more especially talk about Durban's famous road race, which is the Comrades Marathon. I had the pleasure of being out on the road yesterday, supporting lots of runners from our running club, which is now called the Ahmad Al-Qadi Crescent Running Club. Congratulations to go out to Brian Masondo. Brian is a runner that has been part of the Crescent Running Club for many years. He's based at the As-Salam Institute in Bremer, and he finished in a wonderful time of 8 hours and 10 minutes. So he got a Bill Rowan medal. He was aiming for a silver, but I think he had some problems in the second half, but an amazing finish time of 8 hours and 10 minutes. So congratulations go out to him. Also, two female runners, Khatija Kadwa, the daughter of the famous Dr. Ofi Kadwa, 9 hours and 1 minute. Missed her Bill Rowan medal by 1 minute, but amazing run by Khatija. And Durban's famous biokinetist, Raisa Solva, also ran a wonderful time. She ran a time of 9 hours and 29 minutes. So well done to the two ladies. I had the pleasure of running the last 14Ks, supporting two guys that were running their very first Comrades, and they really ran exceptionally well. Not often people can run negative splits. When I say that, I mean they run the second half faster than the first half. But Abdullah Dokrat and Abdul Sattar Ahmad, I ran the last 14Ks with them. Guys did really well, finished in 11 hours 54 minutes. And we're very strong at the end and did exceptionally well for their first Comrades. And they were joined a bit later by Ziad Osman, who also finished in the same time. So three of them literally ran most of the way together. But a special recognition has to go out to Solly Isak. He finished his 20th Comrades, so he achieved his double green number. And he crossed the finish line with 14 seconds to go. So amazing achievement. I had the pleasure of running the last 700 meters with him. Literally tossed him over the finish line just to make sure he got in. But Solly, well done. An amazing achievement. 20 Comrades Marathon, and I hope you now call it quits. At almost 70 years of age, this race is, you had all our nerves really completely wrecked yesterday, but an amazing achievement and well done. So that was about Comrades, and well done to all the finishers and those that even didn't finish, those that just started. You all winners just to get onto the start line. So amazingly well done. With that, it's back to our program for tonight, which is about the succession planning around family businesses. And I do have the pleasure of having in the studio with me from Patta and Patta, Zahra Abdul. She is the corporate commercial associate. So Zahra, assalamu alaikum and welcome to Radio Al Ansar.
Wa alaikum salam, Mr. Moolla, and thank you to all of our dear listeners as well for listening in, and to Manana Chamber of Commerce for affording us this opportunity. Really happy to be here today in studio with you.
Thanks for joining us. The topic for tonight is family-owned business governance, a legal perspective of shareholder agreements or operating agreements. Also with us in the studio today is a very experienced legal person. His name is Irfaan Abdullah. He is the commercial consultant and associate also at Patta and Patta. Irfaan, assalamu alaikum and welcome.
Wa alaikum salam wa rahmatullahi wa barakatuh to you, Mr. Moolla, and to all the listeners out there.
Please address me as Anwar. I feel very old when I'm addressed as Mr. Moolla. So yeah, let's do that. Okay, let's get into the show. Zahra, we're talking about family-owned businesses, but I think we also need to talk about some aspects of succession planning, even on the domestic front, at home, etc. Very often these days, we hear the common phrase is the man's body isn't gone cold yet, and the family is already fighting about the inheritance. And that's a reality, and it has been. We also hear of the what we call the 3-generation scenario, where the first generation makes it, second generation uses it, and unfortunately the third generation loses it. So none of us want that to happen, but it is a reality, and we've seen it in many businesses, even amongst our own community here. We won't go into names and whatever, but it has happened, and unfortunately you find the grandfather probably died saying, I've left my family safe for generations to come, and sometimes within the first or the second generation all that wealth is squandered, and unfortunately that family ends up destitute. So we want to try to put into perspective tonight what can be done from a business perspective to kind of safeguard some of those assets, and more than that, to prevent squabbles. And with squabbles you find barakah goes out of the business,
100%.
and you find that with that goes a lot of other issues. So you are the experts. You're going to be taking us through these kind of scenarios and giving us some of the solutions. So just let's start off with you, Zahra, and say, what is the purpose of a shareholder agreement or an operating agreement in a family-owned business? Because I think this is where it would be imperative to try to set or cast the foundation before going any further.
Well, Anwar, when families go into businesses together, everyone often assumes trust and shared values will be enough. And while that's important, it's not sustainable on its own. A shareholder or operating agreement lays down a clear framework, how the business is run, who owns what, and how decisions are made. It's about building structures around those relationships. It also gives guidance during tough times. Say someone wants to exit the business, or there's a death or even a divorce. Instead of scrambling, the agreement provides a clear process. Think of it like an anti-nuptial agreement for a family business. It's not about mistrust, it's about protecting what you're building. It takes a lot of personal tension out of business decisions. Instead of always needing an elder or a family council to step in, you've got a documented roadmap. Everyone knows the rules from day one.
Okay, so Zahra, you set the ground on a shareholder agreement, and I think it's important to have this because very often in the practical scenario, there's a father who's working a business with one of the sons, as an example, and then when he passes away, that son assumes that the business is his, and then the other children step in and say, hey, hold it, my father built this business, but he said, yeah, but I helped him to build the business. And they say, but we also want a share of this business. And then that's where siblings end up into rivalries and fights, and unfortunately in all of that the business itself suffers until sometimes the business itself is lost and nobody gets anything. So Irfaan, talking about a shareholder agreement, how onerous is it to kind of draw up what we would term a shareholder agreement? Is it a long-winded document?
It can be a long document.
Okay. But what's a simple way of starting the process?
Well, the simplest way is to sit down with the family, find out who the shareholders are. Generally in our community they create a trust, and the trust then is the shareholder. But very importantly is that the shareholders agreement becomes central to the company of that family. But together with that is the memorandum of incorporation of the company. Now, since 2008, the memorandum of incorporation is given preference to a shareholders agreement. Previously, with the old act, etc., it operated a bit differently. But now you need an agreement, a shareholders agreement, that generally kind of marries with the memorandum of incorporation. And you build in these agreements all of the requirements, terms and conditions to protect shareholders. And if it comes to, in your example, father and son, who are the shareholders of a company, other sons are not, then you can build in certain clauses in the agreement where death, for instance, or incapacity can be a trigger event that occurs, and that the shareholder of the person, the shares of the person who has passed away, has to be sold to someone, either to the existing shareholder, right,
Right.
at a fair value, which you can get an auditor to determine, or to one of the other sons, or the other sons as a whole who are not shareholders, to avoid the fact.
Well, not just sons, it could include the daughters as well.
It could them, but then what you need to do also, you remember that a shareholders agreement, strictly speaking, is not a testamentary document. It's not a will.
Right,
So you need a will
right.
that accords with that.
Okay.
So there's no dispute after that. But the shareholders agreement is very important because it determines the relationships of shareholders and sometimes directors in the company.
Okay.
And that's important here.
Okay, Zahra, I mean, even before we get there, I think the critical thing here is communication. And even while a person is alive and of sound mind,
Absolutely.
if they sat down with the family, the wife, the children, and other heirs, there could be parents involved as well, and kind of put forward his thinking so that everybody's on the same page, so to say,
100%,
before the person passes away, that could prevent a lot of bitterness, I'm saying, at a later stage.
Absolutely.
Your
And I
thoughts on
think-
that?
Absolutely, and that ties in with our Islamic principles as well of mashura, sitting around a table discussing what's important. We have the principle as well that we always say it's easier for us as lawyers as well to have our clients gift during their lifetimes rather than when they're gone. Because when they're gone, that's when the most disputes come up. And we've actually had a couple of estates now where there are a couple of clients, their siblings don't agree with them. And they don't agree that that's what the father said or that's what the mother said. So it's difficult to navigate this, and especially quite fiddly when there's a family business involved as well.
Yeah. I had the task of being the executor of an estate of one of my cousins recently. And together with the other executors, although we have a will and we have the wishes and things, we sometimes say to each another, we wish we had an extra 15 minutes with him, because we would have posed these questions, which we kind of
Absolutely.
grappling with, to say, what really was his intention?
intentions.
What really was he thinking about when he put these things down? And unfortunately, we don't have the luxury of that extra
100%.
15 minutes or so that we want. So again, I'm saying, it would
Reduced
be important
interacting.
to sit around a table so that people could also question the person in terms of, is he doing the right thing? Is there a better way of doing it? If somebody is aggrieved, they'd rather be speaking at that stage rather than at the stage
after.
when the person has actually passed away.
If I can interject, I think in that scenario, and as commonly done in our community, is that to create a family trust
Right.
and make the trust the shareholder of the company. So during the lifetime of the shareholder, call him the grandfather,
Right.
he can be a beneficiary as well, but the trustees of the trust will have a discretion to distribute the dividends that they receive from the company to other beneficiaries. So the beneficiaries could be wife, children, adopted children, and heirs.
Okay.
So a trust can go on for 50 years, call it. And then that's where everyone in the family benefits. But again, it has to be a discretionary trust for certain reasons, especially the conduit principle in tax law. And the trustees have the discretion. For instance, let's say a kid becomes a drug addict.
Okay.
We don't have to give him the money. So we can control him, get him treated otherwise.
Okay.
Those kind of things. And you build it in the trust deed, and then there's no squabbles after that. There's no issues of leaving something to an heir or a legatee in a will. Everything devolves in terms of the trust which is created in his lifetime, not in his will.
Okay, that's fine, Irfaan, except that it's critical then to make sure that the trustees are people of absolute integrity, because if there's a issue amongst the trustees themselves, and normally you would have 2 or 3, I would think, then you also could end up with problems. And the trustees themselves need to understand the thinking of the grandfather, so to speak.
Yeah, but they will have met with him.
Sure.
When he prepared the trust deed. He probably would have been a trustee at the time, or when the trust deed is created. Maybe the second trustee is a family member or someone else. The third trustee is always independent.
Okay.
And that independence gives him the right to oversee how the trust functions.
Okay.
And the trust, in terms of our law as it's progressed, is that they have got FICA responsibilities, for instance, which are quite onerous on how FICA operates. And the trustees cannot control the trust as their own, call it property or fiefdom. So they have a responsibility as trustees, as directors do in a company, or a fiduciary duty to the beneficiaries.
Okay. So the trust that you were talking about, family trust, would there be a difference?
Can be any trust. You can call it whatever you want.
Okay. Because very often we do find, and it is encouraged that people do have a family trust, for example, and there have been numerous reasons for having a family trust, and maybe Zahra, you want to come in there, where one would be a means of saving taxes. The other one would be saving estate duty, I think, when the person passes away, because the trust would be an ever-living entity compared to a person when a person passes away, but the trust carries on indefinitely.
Absolutely, and I feel also there will be a higher level of accountability and transparency when you know who your trustees are and who the beneficiaries are for a particular trust. That's especially quite important.
The duties of trustees has become much more severe and strict than before.
That's right.
Yeah.
Okay, we're talking about the shareholder agreement. And the purpose of a shareholder agreement, and I think it's still very important to have a shareholder agreement when it comes to the business, rather than the other issues like the homes and things like that. But particularly in the business, and I think the critical thing again is that the father needs to make it clear to the siblings that are not in the business what his thinking is along the business. How is he going to reward, if I can use that term, the person that's actually assisting him in a business, helping him build a business. Very often the bigger son, and then the other ones go into their own careers. And I mean, it's obviously good to be encouraging children to educate themselves, even if they come into the business, because education never goes to waste. So how would a shareholder agreement help to resolve a conflict if we're going to end up in a conflict among family members? And very often these are also business partners, or what they may not know to be business partners in the lifetime of the person that's leaving this business, but becoming business partners at the later stage.
You're absolutely right, Anwar, and this is why so often family businesses fall apart, not because of poor business performance, but because of internal conflict. These agreements are preventative tools. They say, here's how we deal with disagreements, here's how we vote, and here's how we step away if we must. And if a conflict does happen, maybe over strategic direction or a major investment, the agreement usually requires formal decision-making procedures. This might even mean a majority vote or even a special resolution depending on the issue. It helps remove emotion from the equation. Also, some agreements allow for mediation or arbitration, so things don't go straight to court. Mr. Abdullah will tell you right now, to get a court date, if you apply this week, you'll get it next year, October. So that keeps things civil and private, which is important when your boardroom is also your dinner table.
Absolutely. The last thing we need is a debt in a family causing squabbles, and it's happening more and more often these days. So that's why we're sitting here tonight, and we're talking. So, Irfaan, what are the most critical clauses that should be included in these agreements for family businesses?
For a shareholders agreement?
Well, we're talking about a shareholder agreement.
A company shareholder agreements, right? Very important clauses you'll have there. I mean, if you're looking at the running of the company itself, that's different. We have to deal with resolutions, ordinary resolutions, special resolutions, meetings, quorum for meetings, etc., etc. What rights directors have. and what supervisory rights shareholders have over directors. There are various instances in the law that where shareholders must pass resolutions, but that's within the company. If you're looking at what happens to someone when they pass away, the general trend is you got the shareholders agreement here, and people enter into buy-sell agreements,
Right.
insurance agreements, key man policy agreements, those kind of
That's
things.
absolutely right.
And they can protect the buy-sell, for instance, can protect the family, where the insurance pays out to, say, existing shareholders to buy the shares of the deceased. The money goes into his estate.
Right.
So that's one way of dealing with it when it comes to the issue you posed. You can put a trigger event that on the death of a shareholder, certain things happen. The norm, however, is to offer his shares to the existing shareholders, the surviving shareholders, at fair value.
Yeah.
But you can put in a clause there that on the death of Mr. X, the other shareholders agree that his shares will then pass on to whichever son of his, and he becomes a shareholder of the company by those shares vesting in him. But that has to correspond to what his will says.
Okay, so you could end up having a conflict between a shareholder agreement and a will, if they're not kind of thought out very carefully.
Yes, it's very important to think it out carefully, because as far as the company is concerned, in my view, the shareholder can trump the will, because if the agreement says on death, the value of my shares will be the value of my shares will be valued by a valuer, and the value of that, the shares will be purchased by the surviving shareholders for that value.
Okay.
So that's within the company. That now regulates the company. That's how it operates within the company. And the will say something else. Then you have a conflict.
Okay, we could have another scenario, and I'm going to throw this at you, where a person could be the owner of the business, but he's also got a partner that's non-related. So in other words, there's two partners that start this business, maybe own 50% each or 51-49, and the other partner is not somebody that would inherit from his will. It's a totally independent party. Now, they can end up being a kind of conflict scenario between the outside party, so to speak, and the family that now has inherited part of the business. I mean, how would you kind of handle something like that?
The other partner will remain a shareholder on the death of the deceased. Right? Sorry.
Yeah.
And if the deceased's will says that his shares will be inherited by whichever child of his, then those shares will vest in him. It won't create a conflict unless the shareholders agreement and the memorandum of incorporation says otherwise.
Okay. Zahra, I'm going to ask you to come in there, and from your practical experience, and you handle this all the time, what are some of the common mistakes that you've seen in family, business, government documents, be they shareholder agreements or other documents? And how can these be prevented?
Anwar, it's funny because you would then expect them to have a document in the first place to have mistakes. And I think that's the first mistake, that they come in, they have no documents in place, they already have disputes going on, and that's the point that they expect us to resolve and to put a document in place. And it's difficult to get all seats at the table, when there's already a dispute in place. So I think it's never too early. That would be the first piece of advice.
So your first advice is put a document in place, whatever that is.
100%.
Okay.
100%.
And what the problem is with our existing businesses in our community, again, is that they've just issued share certificates and they have no underlying document.
Okay. Okay, so Zahra, carry on that light. That's the first mistake, is make sure you have a document in place.
Absolutely. You're basically relying on verbal understandings and the default provisions in the Companies Act and a whole lot of goodwill, which can evaporate the moment there's money, conflict or change involved. And the consequences can be massive. For instance, without a preemption clause in your agreement, a family member could legally sell their shares to a complete outsider. Without rules for succession, shares could pass to heirs who have no interest or capability in the business whatsoever. And in disputes, courts will have to step in and make decisions, which is slow, as we've discussed, expensive, and very public. That's not ideal for any business, and definitely not for a family one. It's not about just protecting the family as well, it's about protecting the business too. Imagine one shareholder passes away and their spouse suddenly wants to sit in on the board meetings or influence decisions. If there's no agreement, you may not be able to stop that. And we have seen, Mr. Abdullah will tell you as well, we've seen families torn apart because one member thought they had certain rights, but the law said otherwise. And that's why we always say, even if you're 100% on good terms now, get it in writing, because emotions run high when money, control, or legacy is at stake.
Money, they say, is a good thing, but also can end up being a very bad thing. And money has very often torn siblings apart, led to family feuds, sometimes costing millions and millions of rands in court fees. And then, unfortunately, the only people that make the money are you guys sitting here, which are the lawyers.
We try and avoid those litigation costs.
Well, you say you try to avoid those litigation costs, but let's be realistic. If we were not for that, you wouldn't be able to put some food on the table.
Litigation costs are very high now.
Yeah. So and then when the court rules against your client, then you say, but the judge wasn't fair. But anyhow, that's the role that you guys play, and I'm sure you do it in all sincerity, trying to protect people, and that's your responsibility. And that's why we're sitting here trying to say, how can we prevent these mistakes, if you want to call them mistakes. So Zahra, you were taking us through some of the mistakes. One is, first and foremost, have a document in place.
Absolutely.
Whatever that document is. And again, they say do not go to sleep if you don't have a will in place. So from a domestic perspective, from a family perspective, have a will in place. The reality is nobody expects to die, and that's what it is. So no matter how old you are, you think you're going to live on forever, and nobody lives on forever. So that's the reality. There's only one reality in life, and that's death. So we have to take cognizance of that and have the documents in place. So
I think quite impactfully, Anwar, the point you touched on earlier, in terms of passive family members in the business and active family members in the business. You know, you have situations where there's one sibling, they work 12 hours days in the business, and another lives abroad, and they just collect dividends. It does cause real tension. We've seen it up front. And a good agreement, we feel, a shareholders agreement, can separate the ownership from employment and clarify the difference between being a shareholder and just an employee or a director. You know, it's real life situations, and you can specify then in that particular agreement who gets paid a salary versus who earns just from the profits. You know, then at least the parents are at ease. They think, okay, our kids don't think that we were choosing a favorite or one over the other. You know, the ones putting in the work are compensated fairly, and those who are just investors still get their share based on the ownership. We've also seen that agreements that require family members to apply for roles, meet certain qualifications, and this also will then help that business stays professional and merit-based, not just inherited because, you know, that was your husband's business or something to that effect. It's also about, I think, managing expectations, and we see it all the time. Just because you have a 20% share doesn't mean you automatically get a job or say in daily operations. You know, the agreement can define that active family members run the business while passive ones get financial updates or attend certain meetings. And we know for some of our khalas out there, that's the better option. You know, it helps avoid the resentment as well. Everyone understands their role, whether it's leadership, oversight, or just investment. And if someone wants to become active later as well in the business, there's a process for that too. So it's also good governance. You know, as Mr. Pathar does say all the time, family businesses that separate ownership from management tend to survive much, much longer.
Okay, I mean, some excellent points there, Zahra. And Irfaan, I mean, we've seen also in family businesses where the father is trying to create a role for his son, so to speak. And very often this youngster walks into the business, sometimes fresh out of school, sometimes with a university degree or some sort of degree. And you have senior management in place, and suddenly this youngster that comes in sits on top of that senior management, much to the dislike of the senior management, disillusioned in many cases, having to take instructions from this kid that has just walked into the business, and things like that need to be avoided as well. And these are practical, you know, kind of things that we're seeing in the business world.
Yeah, so you document that to protect the senior management, and the process of appointing the son. The son may be a shareholder.
Yes.
He could be a shareholder, so you're going to appoint him as what? A director, sitting on the board. So you have a separate process for that, a separate agreement, appointing him, and even giving him with the say-so by way of a special resolution of shareholders, a salary, a remuneration. But being a member of the board gives him some say.
Okay.
Gives him some say by which the management needs to abide. But what you build in that agreement with him is that you consult with the senior managers. You consult with any senior officers that you have in your company. And then you come to a decision which he has to do in the best interest of the company. Because he has a fiduciary duty to the company. If he doesn't do that, then he's in trouble.
Yes, I think, but also there's a responsibility for a father, so to speak, or grandfather, who spent years and years building up this business, blood, sweat and tears, and then you get a youngster coming in to kind of let him put his toes in the water, and then before he dives in, because you can end up with, and they say fresh blood is good, and bring in the youngsters, and they've got all this IT and all of this wonderful new techniques that they come in with. But sometimes the old way is the best way, and change is good, but change has to be quite gradual.
Yeah, you're correct on that. So start him slow,
get him there, and then as he's proving himself, then you give him more.
Absolutely.
So Zahra, the implication if a family-owned business doesn't have a formal agreement in place.
Yeah. It's when a shareholder passes away, and then you're dealing with all of these things on the table, and you don't know how quite to go.
Firstly,
about
you got the emotional issues of the person
Exactly.
having passed away, and then you got all of these things. Yeah.
You've got all of these issues, and then you've got people want to inherit this asset, they want to take this. It's quite tricky, but you have to take everybody, have a roundtable conference with all of them, and just unpack every single thing that comes to the fore, because that's the only thing you can do at that particular point in time.
Well, we talk of a roundtable conference, sometimes easier said than done, because there's already some sort of rivalry that's been simmering
Absolutely.
under the
You
radar.
get lawyers letter to and fro. Yeah.
And sometimes that rivalry is kind of kept at bay because of out of respect for the person or the incumbent person. And the moment his eyes shut, so to speak, then that goes out of the window, and then it becomes a full-blooded fight.
And it becomes, they promised me this, they promised me that, I gave this money in cash, this is what I invested all of my years. And it's that type of thing where you really just need everyone to be able to communicate, transparently sit and discuss what needs to be done, and also just focus on what's important at that time, which is trying to responsibly come to a conclusion.
Okay, let's go for a small ad break, and when we come back, we're going to have a few minutes left. Time does pass fairly quickly, and we're going to be rounding up with Zahra, Abdul, and Irfaan, Abdullah, about agreements that can be put in place to ensure success and continuity in family-owned businesses. Assalamu alaikum wa rahmatullahi wa barakatuh. If you've just joined us, it's the Business Matters program on Radio Al Ansar. Business Matters brought to you by the Minara Chamber of Commerce. I have had the pleasure of speaking to Irfaan Abdullah and Zahra Abdul, both from a very, very recognized legal firm called Pata & Pata. Zahra keeps reminding me that they were voted the best legal firm.
And nominated for this year as well.
And nominated for this year for 2024. So well done to Pata & Pata. And we do have two of the esteemed people from that firm with us this evening. So Zahra, before we went for that little ad break, we were talking a bit about not having agreements in place. But we also, and you can kind of answer this and Irfaan can take it further, is we also need to be cognizant that any agreements that are in place are within the ambits of Sharia, because
Absolutely.
That is something that is absolutely critical.
100%. I don't think one should lose sight of the fact that it has to be aligned with Sharia principles. Even just getting consultation done with an ulama, with a mulana, with an esteemed leader of the community, just to ask what their opinions are. And, ensure that all practices, whether it's a will, whether it's a shareholders agreement, are aligned with the Sharia principles. especially the event of death, like Mr. Abdullah has been saying during the break. It's so important just to ensure that alignment is there.
Okay, you want to...
On with the shareholders agreement, on death, we call it a trigger event. On death, what happens is that the shares, instead of devolving to the deceased heirs, will then be bought at value by the surviving shareholders.
Okay.
And that value then is paid into the deceased heirs deceased estate, to be distributed in accordance with Sharia. What we can also do, and we have done this, when it comes to deadlock with decisions within the company,
right,
we refer the deadlock. I normally make the KZN Jamiat as a referral point to try and resolve the deadlock. So we apply Sharia principles in resolution of the deadlock.
Okay. Okay, we've been talking about existing businesses that have been around for a while. But let's just focus a little bit on, and we've got a few minutes left, on businesses that are new business. A family is starting a business together now. Zahra, what advice would you give when drafting their first agreement, the really first agreement, now at the really inception? Should they, at that stage, already be working with a specialist attorney like yourselves?
Please don't just download a free template and think you're covered. Every family is different, and so is every business. Our biggest advice is, I think, Anwar, they should sit down early, have the hard conversations about money, power, exit, death, divorce, and then they should put that into a solid agreement with the help of a specialist. A family commercial lawyer understands that not just the legalities, but also the psychology behind these relationships. We would know how to ask the right questions and just craft the clauses that help reflect their values, their risks, and their long-term goals. You'd be surprised, just for a couple of conversations with a client, we already know where they're heading and what they need to achieve. The process itself is invaluable. Just sitting down as a family, going through these scenarios brings clarity and alignment even before the ink dries. We'll also just make sure they're covered in terms of things they haven't even thought about, like valuation methods, as Mr. Abdullah touched on earlier, or what to do if one of the siblings wants to leave the country or marry someone. These things matter. And remember, we're not just writing for today. We're drafting something that may guide our kids or grandkids that decide to join the business, as you said, in terms of the youth getting involved. We need it to be legally sound, flexible, and fair. We don't want to go to court and have disputes all the time. We'd much rather have transparency and accountability from the start. And spend the money now on a good agreement. It'll save you 10 more times in legal fees and heartache down the line.
Also, I think when you guys are drafting those agreements now, you'd also be taking the tax considerations at a later stage into account, because you really don't want a thriving business to be burdened with massive amounts of estate duty, etc., and that then affects the cash flow of the business and puts a strain on that business unnecessarily.
Absolutely. And what we even say is, even when you're gone, you have to pay tax. Yeah. That's one of the points that we always make. And I think Mr. Abdullah, with all his experience as well, would be able to touch on that point.
Okay, some parting comments to Irfaan.
Well, Zahra is correct. An agreement is necessary. These new startup businesses. An agreement is absolutely necessary, and we would suggest form a company. Prepare the memorandum of incorporation and the shareholders agreement. Tie things up as best as you can for them. Tailor-make it for them. Don't use a standard agreement. Tailor-make that agreement for them.
Okay.
It may be costly, but rather pay that upfront than pay litigation costs which are huge, extremely huge. And that's my suggestion to all startup family businesses. When it comes to tax, that can be built in within the corporate structure.
Right.
Dividends tax paid to shareholders, withheld by the company, paid to SARS then. And try and, as best, avoid estate duty if you can.
Okay.
Within that structure.
Well, I think none of us enjoys paying taxes, whether there is estate duty or whether there is any other form of tax.
Unfortunately, even the company pays its tax and the shareholders pay their tax on dividends.
Anyhow, Zahra, some parting comments from you.
I think, what we've emphasized on is communication, it's preventative measures, it's coming forth and just making mashura, which is aligned with our Islamic legal principles, of course, and just always having, at the forefront of your mind what you'd like to achieve with everything. The intention, I think, should be made first. Niyyah is the most important thing.
Absolutely.
Something my father always says as well, and, intention is so important to go forth with. Yeah.
And
Lovely.
just as a parting shot from me, is that for Muslims, as I said to you during the break, in Sharia, contracts are important.
So have a contract.
Conclude
Surah
a
Bayyinah.
contract.
Surah Bayyinah.
Conclude a contract, whether it's a sale, whatever. Have a contract. So
Bring
there's
it down to writing.
Yes.
That's the bottom line.
Yeah.
Okay, excellent. Zahra, Abdul, Irfaan, Abdullah, thank you for being with us tonight.
Thank you for having us. We're very fortunate to be here today.
And lovely, thanks for enlightening our listeners on business governance and what they should be doing to avoid some of the issues that community is faced with today. So Jazakumullah khair and
Ameen.
And Jazakallah to you as well.
Thank you for
having
coming
us.
in. Excellent. That's the program for tonight. Inshallah, we'll meet you again for another exciting Business Matters program next week. With that, it's wassalamu alaikum wa rahmatullahi wa barakatuh.